I'd like to introduce Harlan Yu, who will be speaking about access to federal court records. Harlan.
Thanks, Daniel. And thanks to Representatives Quigley and Issa for chairing the Transparency Caucus and for the Advisory Committee on Transparency for inviting me here to speak with you today. I'm here to discuss public access to federal court records. And certainly for this audience, it shouldn't be necessary to discuss at length why court documents are so fundamental to our democracy. In almost all circumstances, ignorance of the law is no excuse for breaking the law. And so one would assume that the law of our land, and in this case, the documents that form the basis of our common law, would be freely available and accessible, without discrimination, to each and every citizen who wishes to learn her civic rights and responsibilities. But today, this is not the case. Today, access to the law and to justice itself is discriminatory. It is biased toward the wealthy, to those who can afford access to primary legal materials. Let me explain. The US courts runs an online access system called PACER, which stands for Public Access to Court Electronic Records. It provides real-time online access to information about all federal district, bankruptcy, and appellate court proceedings. The system charges users 8 cents per page, where a page is effectively defined as a screen full of data. If a user searches for a case with a defendant named Smith, which returns 10 pages of results, he will be charged 80 cents, 8 cents per page. If he then accesses a case docket sheet, he might be charged an additional 40 cents for those 5 pages. And a subsequent download of a single 20-page brief will cost him yet another $1.60. And while at first this might not seem like a lot of money, it is. It adds up fast. And for many users, PACER's paywall is, if not extremely limiting, fully prohibitive. In a survey conducted last year by Erica Wayne at Stanford's Law School, she found that even at our nation's top law schools, a vast majority of their libraries restrict direct access to PACER by their own students and faculty. What they're deathly afraid of is an unexpected and huge PACER bill. For instance, one Stanford student last year, in a matter of hours, ran up a $500 tab while doing legitimate legal research. As a result, almost all law schools around the country ration their PACER usage. Legal scholars wishing to shed light systematically and empirically on the inner workings of our legal system as a whole are effectively shut out as well. The PACER repository contains over 500 million documents. And for a project that requires analyzing a large portion of these documents, a fee of 8 cents per page quickly puts an end to the idea of conducting that research. So too harmed are nonprofits, investigative journalists, pro se litigants, and other concerned citizens with an interest in our judicial system. So you might be asking, why are the courts allowed to charge for access to the public record? Their authority comes from the E-Government Act of 2002, which specifies that the Judicial Conference may prescribe reasonable fees for electronic access to court records, but, and I quote, only to the extent necessary. The purpose of the fees is to, quote, reimburse expenses incurred in providing these services. There's substantial evidence that the courts have been far overstepping their statutory limitation. My colleague at Princeton, Stephen Schultz, has been voracious in his investigation into the finances of the federal judiciary as it relates to PACER. I would highly recommend reading his recent blog post and his white paper on the topic. In short, the courts are charging users at least 4 times as much as it costs to run the PACER system. Their budget documents for fiscal year 2010 show that they expect to collect more than $94 million in PACER fees this year, even though only $21 million are direct expenses for providing electronic public access. This $73 million difference this year, along with carryover revenue from previous years, total more than $100 million, which are then used to fund other technology projects, courtroom technologies like flat screen monitors, and general telecommunications expenditures, which are not directly related to electronic public access. I'm not opposed to these projects, but they shouldn't come at the expense of free and open access to the law. So what can Congress do? It's really simple. Repeal the language from the 2002 E-Government Act that allows the courts to levy user fees for electronic public access, and in turn, prohibit them from charging for this information. There will be some practical difficulties to doing so, to be sure, but repealing the statutory authority with appropriate sunset provisions will get the right gears turning. We can discuss specific considerations in our conversation to follow. But to conclude, I'd like to quote from the Senate report that accompanied the 2002 E-Government Act. It noted that the committee intends to encourage the Judicial Conference to move from a fee structure in which electronic docketing systems are supported primarily by user fees to a fee structure in which this information is freely available to the greatest extent possible. For far too long, access to the crown jewels of the public domain have been artificially restricted to the detriment of our society and our democracy. Now is the time to free these documents and to provide our citizens with equal unfettered access to justice and to the law. Thanks.